Okay, hello everyone again. Welcome to our next installment of the Lunch and Learn program. Today we have Jeremy Kostiuk from our Phoenix Community Law Center. Jeremy is here to present on sexual assaults and pretrial applications. To give you a bit of background about Jeremy, he moved to Winnipeg when he was 1 year old. He's lived here ever since that time. He graduated from U of M with a BA in English in 2000 and then graduated from Robson Hall in 2006. He then articled with Phillips Aiello and worked there until 2012 when he then moved to the Zeman Law Corporation with Sahil Zeman. He worked with Sahil until the summer of 2024 when he joined legal aid at our Phoenix Community Law Center. So Jeremy's always had a large practice when it relates to sexual assault offenses and lots of experience with high-risk sex offending clients. So he is here today to impart his knowledge onto us. With that, I'll pass on to Jeremy.
All right, welcome everybody. So, sexual assaults. These are cases that I feel like junior counsel tend to shy away from. And I understand why, because you kind of need to know what you're doing in order not to have a miserable experience doing them. It's very easy to sort of take one on early in your practice, not really have a lot of guidance in how to approach particularly cross-examination. And then what happens is you get raked over the coals by both the Crown and the judge. You walk away feeling pretty dismal about it, and then you're not really inclined to take them on further. And so the notional topic for my presentation is the pretrial applications, sections 276 on prior sexual history and 278.1 and following on records in sexual assault cases. And I kind of struggled with that in a sense because while these are they tend to dominate the thought process when people are sort of learning about these cases and assessing them, but they're not really a pathway to victory for the most part. And so while you need to know about them and how to do them, more important is knowing how to do and win cases without them, because most of the time most of these applications, as a matter of statistics, fail, and they fail for different reasons. But I'm going to go through this stuff so that those few of you who are listening have a sense of it. And then I'm going to talk about why you kind of want to avoid these to the extent that you can. You can't be afraid of them, but they're not the main thing you should be thinking about when you're approaching a sexual assault case. So Section 276 was the first of these sections to come into force. And it was, at least on paper, a response to one of the historical strategies for sexual assaults, which is just dredging up a woman's sexual history, calling her unchaste or whatever sort of more flavorful thing you want to call her, and dropping the mic and then watching the jurors acquit. I don't know that it was ever really that simple, but I mean, certainly I apprenticed with people who grew up in that day and age, and told me all about, yeah, that's what we used to do. And so what this has done is it has led to 276 and 278. And in a way, we're all kind of paying for the sins of our forefathers, because these sections have a tendency, in my view, to at least potentially also distort the fact-finding process. but the attitudes don't toward these are only going to change generationally and slowly. So what we have is what we have to live with, and you just need to learn how to navigate it and how to approach these cases with confidence. So the the fundamental idea is that Section 276 is designed to avoid the traditional, quote, twin myth reasoning in sexual assault files, which is that a woman who had previously consented to sexual interactions outside of marriage or a committed relationship was either more likely to consent to sexual activity or is less worthy of belief. And I don't know that people really still think that way, although our experience does teach us that your choice of partner kind of, informs what, your character and people will think about you, but you can't sort of approach court like that. So Section 276 and 277 basically prohibits calling any evidence of sexual activity for the purpose of that twin myth reasoning, and requires going through the procedures outlined in sections 278.93 and 94 if you want to broach the subject area. But in order to do these, you need to know fundamentally why it is you want to call this evidence. And when you really examine it, a lot of the reasons you're going to want to call this evidence really will boil down to establishing that the complainant is more likely to have consented, which is why the applications will tend to fail. Even if you're not, if you sort of are trying to parse it differently, a lot of it simply comes down to that. Now, one of the main reasons that you want to do it, and one of the sort of frustrations that you can have in trying to evaluate it, is that a lot of these cases will come up in these sort of nebulous relationships where two people, they're not dating exactly, but they're still screwing regularly. And your worry is that this single incident complaint, in the absence of that context evidence, is just going to come across as, your complainant out of the clear blue with no kind of backstory explaining, why he expected to get laid that day, is, approached the complainant and proceeded the way in which he did. And a lot of the case law specifically discusses like a general assertion of context as being something judges really have to watch out for, and they will. So one of the most tempting uses for a Section 276 application is to, you're not trying to slag the complainant in the sense that you're accusing them of, having slept with your client on 3 other occasions. Therefore, they, consented on this 4th time where she says she didn't. But you're just trying to establish the backstory because you don't want the backstory distorted. In front of most judges, that application is going to fail because the mere fact that they slept together X number of times previously and it all went fine isn't really informative of whether or not this most recent time was consensual or not. But you still don't want to have that distorted finding of fact. So you need to just find another way to get that context sort of without the sexual activity and let the judge fill it in. The last sexual assault trial that I did that I lost was one of those kind of situations where it was one of these situationships where the complainant was chasing my client, and my client would, he was kind of a douchebag by his own admission, and would have sex with her when he'd had enough to drink or had done whatever drugs, and kind of treated her like a dick when he was sober. And so I didn't do a 276 application, and there were a few alleged sexual assaults, but there were a whole bunch of times by both of these people's sort of admissions that, were just regular consensual sex. And so I declined to do a 276 application, and we just sort of talked about the relationship, and I had questions about, him, about the complainant chasing the accused, and, she kind of denied it. And the judge actually in the decision specifically said it seems clear that there have been a number of other sexual encounters that were not brought into evidence, and there was no application, but I still, it seems fairly clear from the facts. Judges aren't stupid. Judges are going to get that there were other things. And so the worry about distorting the facts in that way by there being no evidence of previous sexual encounters is something you can head off just by approaching the relationship, the surrounding relationship, by fleshing that out enough. And so one of the main pitfalls that you have is that if you approach that through a 276 application, most judges, I think, are going to tell you no, but that doesn't mean that you can't do what it is you want to do in a more subtle way. And that may not actually that information may not find its way into the written or spoken reasons for judgment, but you can still get it done in that way. So for the time being, the judicial attitude toward this topic is that we're never going to get past 1970. And so these protections aren't going anywhere. But judges will change slowly, but this is a job where old people tend to hang around. So the judges who formed their politics in the 1980s, they're still around, and you need to be able to navigate this. And so rather than setting up a head-to-head confrontation with the judge, arguing something that they don't want to hear, you can get the information in the other way. Now, where I've found that these actually tend to be useful is in DNA cases, where DNA comes back and the owner of the DNA is not the person you would expect it to be. There you have to do a 276 application, and you can't fail to do that because it is only through that portal that you can get that DNA evidence. And remember that any pursuant to 276 sub 4, any communication that is either for a sexual purpose or sexual in nature is also covered by this section and requires a specific application pursuant to section 278.94 and following. But you don't have to do that application where the sexual activity is the subject matter of the charge. And that, for instance, if you've got communication or evidence of communication, and I'm not talking about the actual records because that's separate. If you've got text messages and stuff, you still need to do a separate application for those. But the fact of communication between the parties leading up to the events that form the subject matter of the charge, that's not something you have to do a 276 application for. Now, there has been another development in the sense of human trafficking and related matters that are not specifically enumerated in Section 276. But you may still have the section may still be applicable if the facts of a sexual assault or one of the other enumerated sections is captured within the subject matter of the charge. So if your client is merely charged with some human trafficking, living off the avails of prostitution or whatever, but with the facts of those allegations include a sexual assault, you may have to do a 276 application, despite the fact that your client is not specifically charged with one of the enumerated offenses. So that's something you do need to be aware of if you're going to be taking on these kind of beefier sex-related cases, because that's something that can come up and bite you if you're not aware of it. But fundamentally, questions about sexual history, you do need to know how to address them. Now, Section 276 does also apply to the Crown, but the Crown is not required to engage in the procedures set out in Section 278.93 and 94 in order to do that. So they have to, their evidence that they want to call about previous sexual activity is subject to the same screening function, but they're not sort of stifled by the procedure in the same way that the accused is. So that's Section 276. Section 278.1 and following up to 0.93 is about records, and specifically the application for production of third-party records in specifically enumerated sexual offenses. Now, this seems to be strictly confined to the ones that are, to charges that are listed. Now, expressly in terms of the statute, it covers medical, psychiatric, therapeutic, counseling, education, employment, child welfare, adoption, social services records, personal journals, and diaries. Those are all specifically enumerated, but the section covers anything with an expectation of privacy, and anything or just about anything that you might want in defending a sexual assault case in terms of third-party records is going to be something where some expectation of privacy is engendered. So you need to be able to do these applications. They're not complicated. They're just fussy, and you need to make sure that you've got everything done in writing. This was the second of the 3 papers in here. Now, the MS decision, that's a 2019 Ontario Court of Justice decision, provides a laundry list of factors to see if something is a record to which a reasonable expectation of privacy attaches. And it's going to realistically be anything that you want on a sexual assault file. There are levels of intimacy, like not everything that you're going to want is going to be a personal journal or a therapy record as a result of a sexual offense, but it's going to be something to which a reasonable expectation of privacy attaches. In order to, the application fundamentally is a 2-stage process. You have the initial stage where basically you need to establish that there is but that the record is likely relevant to an issue at trial, or less often, the competence of a witness to testify. Now, that's not a high threshold to meet in terms of the test. It just means that there's a reasonable possibility that the record contains information that's logically probative to an issue at trial. But also don't forget that implicit in that requirement is you need to establish that the record exists, which is easy to forget about, but is actually one of the things that can operate as a bar on a practical level. Particularly, there's a trap that you fall into as defense counsel that deals with, you have a certain fluency with, social services agencies, child and family services. We know that people keep records and make notes, but you need to establish that in the evidentiary record in order to have a chance of succeeding. Because, the judge might well know, as a human being sitting there having presided over cases for 20 years, that social workers, take notes when they interview their clients in the main. But if you don't establish from, the complainant or the social worker or whoever else that this was happening, the judge is just, when you ask for disclosure of the record, the judge will just say, well, what record? What are you talking about? She might have made notes, but you don't have any evidence of that. So don't forget about establishing on a balance of probabilities that the record exists, because it sounds like something so basic, it's like something basic, but it's so basic that it's often overlooked, and that can actually hurt you on these applications because they become a non-starter, whereas a few more questions during your examination. Because sometimes these are going to be mid-trial applications where the existence and relevance of the record is only disclosed in cross-examination. Judges are not going to be thrilled about it because we used to have preliminary inquiries to do these things pre-trial. Now, judges know that we don't get prelims on these things anymore, but that doesn't make them any happier about mid-trial applications. So, if you're going to do one of these things, you want to make sure that you have really laid the foundation for it, because the judge hearing the application that is about to derail the trial that you have set for 2 days and now is going to need an adjournment and continuation dates, they're not going to be positively disposed to anything you're doing, whether they recognize the need for it or not. So stage one, that's the only requirement, is to establish likely relevance. But it's not a high evidentiary threshold, but the judge is going to, you need to be identifying specifically what that is relevant to. And again, you need to be able to articulate these. Judges tend to be very protective of sexual assault complainants, both in terms of cross-examination and disclosure of records, in order to sort of rectify the fact that, sexual assault trials can be invasive. And that's a legitimate objective, and it's something you simply have to go through. Now, once you have established probable relevance, if you've done that to the judge's satisfaction, then they order that whatever records they've decided are probably relevant get produced to them for review. You don't get them produced to you, but you will get some indication of what is there. You can't be expected to make argument if you have no idea what's there. So you'll get some information about them. And from there, the judge engages in the balancing test in terms of essentially the importance of the evidence and the need for it to make full answer in defense versus the privacy considerations that are engaged. I'm not going to walk you through the laundry list of factors. They're spelled out explicitly in the statute, and the case law sort of expands on them a little bit. And they're not entirely limited. Different pieces of evidence will raise their own fact-specific issues in terms of privacy, administration of justice, and anything that sort of inherently dissuades sexual assault complainants from participating in the system. It is assumed without any actual evidence that the existence of the possibility that you may have to disclose some of your records will stop people from disclosing sexual assaults. I don't know that there have ever actually been any studies that assert that, but that's the assumption behind the legislation, and you simply have to live with it. Now, complainants are entitled to counsel, record holders are entitled to counsel. Anyone who is affected by the disclosure of the record are all entitled to counsel. And all of these people need to be served up front. Not everyone who's in the record, because you don't know it, but you have to subpoena the record holder with a subpoena that directs them to bring the documents. You have to have all of that taken care of, and judges will take you to task. And sometimes these things come up on short notice, so you have to be prepared to move quickly when it does come up. That's also true in just O'Connor applications, third-party records applications generally. You need to be sometimes prepared to move quickly because when they come up mid-trial, and they will come up mid-trial frequently enough, you need to be able to move quickly in order to minimize the amount of upset that the judge is going to be experiencing as a result of this. So, and if the judge now in possession of the record is of the view that some of what has been disclosed to them, some or all of it, is necessary for the accused to make full answer in defense, it will be disclosed to you subject to conditions. And those conditions are some of your best persuasive arguments in terms of managing the prejudice to the complainant's dignity and the administration of justice. So these can be restrictions on disclosure and access to the record. I mean, normally we're not in the business of broadcasting the contents of our files anyway, but these are things that you definitely want to be putting forward because they offer and they make it easier to say yes to the application when you're sort of showing up at the table, acknowledging that there are real privacy and dignity concerns, and that they will be taken care of. And the other main one is restrictions on the questions that you're going to ask as a result of getting whatever it is that you're going to get. So fundamentally, your main approach to take when you're asking for these things, whatever it is that you're asking for, is you want to be generally acknowledging that component of it, unless it's the kind of thing where the expectation of privacy is really very sort of tangential and limited. The most useful stuff tends to be personal, and so that's what you have to acknowledge when you're making the application. And then restrictions on what you plan on doing it vis-a-vis cross-examining, particularly the complainant. Only tangentially related to them, that's less of a worry, but mostly it's going to be something that you want to cross-examine the complainant with. And so you want to certainly appear to be sensitive to those issues. Now, social media, a lot of this will be social media stuff. And that sort of segues into the third component of it, which is section 278.93 and for 9.2 and following. Because mercifully, it's the same procedure for all of these when you're doing the application. But the records, once you are in possession of records, whether that is as a result of a third-party records application that you have done, or just something that your client and client's other resources or witnesses have access to, then you need to launch an application in order to use any kind of record again where there is a reasonable expectation of privacy attaching. And again, you're dealing with the same analysis in terms of the probative value and relevance and necessity to make full answer in defense versus expectations of privacy and dignity of the complainant. And you're dealing with this, again, the same kind of analysis in terms of twin myth reasoning where it comes up. Records that have sexual content to them require a 276 application. So if you have a record that your complainant has, often that'll be social media, a chat history or text messages or something like that from the complainant that doesn't bear directly and sort of proximately to the actual alleged sexual offense, but is still sort of relevant. If there's a sexual component to it, you need to do a 276 application. A 278 application is not adequate if there's sexual content to the record that you are attempting to adduce. So make sure you're doing the application under the correct section, because that's an easy way to look stupid in front of your client and delay the trial in a way that pisses off the judge. And you don't want to be pissing off the judge in these applications. They're a little more ginger than they should be because of the tendency of judges to be protective of sexual assault complainants.
So do you need two separate applications then if it's like a Facebook Messenger where they're talking about having sex?
You don't.
Then you can just put it in one with the two headings of like, this is
Yeah, you don't need,
and
no, you don't need to do two separate applications. You just need to make sure that you're applying under the correct section and that you're considering all of the correct statutory provisions to do it. And the third paper that was put forward at the criminal law component is one, or the conference was one on case management. And it is mostly directed toward the judiciary and in part toward counsel in terms of have your ducks in a row. But I wanted to talk about it because as defense counsel generally, and more specifically in sexual assault cases, there is a lot of pressure on you to avoid delay and to make sure that trials go smoothly. And as defense counsel, you're in kind of an awkward position with respect to those issues because there's a fundamental tension there. Like our ethical obligations to the law society, require addressing issues and communicating with opposing counsel and, narrowing the field of litigation to what is actually an issue. But at the same time, there are two, I found, inescapable truths of criminal trials. One is that all other things being equal, delay favors the accused. And two is that all other things being equal, a smoothly running trial favors the crown. And so being too agreeable and working too hard to ensure that the trial runs smoothly does in fact run the risk of prejudicing your clients, not by adducing evidence that operates unfairly to them, but just by being smilingly cooperative with a process that is designed to kick your client in the ass. So certainly some of what you will hear about case management is something you should follow. Like when you have case management conferences, be prepared and know your file. Like you're not always going to be perfect with the time pressures that we're under, but show up knowing the file and knowing what you want to do. But beyond that, don't be too eager to make agreements. I mean, yeah, you look reasonable when you're making agreements, but judges don't really remember you for the agreements that you make during the course of trials. You get remembered for doing a good job defending your clients in a way that doesn't piss off judges. I mean, they'll also remember you if you piss them off. You don't want to be remembered for that. But being too eager, there's no reward for being the lawyer who makes the most agreements in the course of any given year. You don't get a sticker. And we've all had experiences, if you've done enough trials, where you've made an agreement that in the end you come to regret. So, like, if you're feeling pressured to make an agreement, just say no. If you're not comfortable making the agreement, or you're not entirely sure that the agreement being sought is harmless. I mean, the worst that happens is the judge kind of rolls their eyes at you and, mutters something stupid to the judge next, in the office next to them when they're done the case management conference. But like, if that's the worst you ever have to deal with, then, you're doing pretty well. So, yeah, you need to have a mastery of the issues, but beware being too agreeable in setting these things up. If you're not comfortable making an agreement, or you're not certain that the agreement is harmless, just don't make it. The worst thing that happens is you waste a little bit of time on adducing some piece of evidence that you're not really in a position to take a swing at. It's not the end of the world. So we're 20-1. I'm wondering if at this point anybody has any questions about any of this, anything I've covered, or just questions about these things generally. Before I open that up, I wanted to talk about, there's one more thing I wanted to talk about, which is that when it comes to these applications, particularly the applications for third-party records, the first question you should be asking yourself is, can I win this trial without it? I've won a lot of sexual assault trials in my career, mild boast. And in all of those wins, I can identify one of them where the 276 application I did was the reason that I won it. And I cannot identify a case where a third-party records application was why I won it, or the having some text messages that my clients were in possession of. I have no wins as a result of that. The way, in my view, to win sexual assault trials is, in most cases, to do the one thing that the law tells you that you don't have to do, which is identify why the complainant is fabricating the allegation. You don't necessarily just want to ask your client, why is the complainant fabricating it? That is too blunt a question, and your client may not directly know. I find it helpful to treat sexual assault cases as reverse onus cases, where the onus is on you to prove on a balance of probabilities that the complainant has a reason for making this up or perceiving what it is that they are perceiving. That doesn't necessarily have to come from your client. If you do enough of these cases, it won't take you that long. Like, a lot of guys who are charged with this stuff have nothing intelligent to say about it. And frankly, a lot of our clients aren't all that bright on their best day. So that they may not be able to help you. Sometimes they can. Sometimes they're great, but often they have nothing intelligent to say. And you, as human beings, tasked with the job of deciding whether someone is guilty or not guilty, the first question a human being asks when they hear about a sexual assault allegation is, if that's not true, why are they saying it? That is an inescapable question of human nature. And just because the law doesn't require that you have the ability to answer it, doesn't mean you shouldn't try to answer it. That question, more than any other, is the difference between who goes to jail and who goes home after the trial, in my experience and view. So you need a theory when you start cross-examining witnesses in a sexual assault case. You need a theory about why the complainant is making it up. That theory should be specific enough to guide your questioning, but broad enough to accommodate unexpected bits and bobs of evidence. If it's too specific, then you run the risk of stumbling over some other piece of evidence that nukes your theory, and then you're just screwed and you kind of look and feel like an idiot. So don't be overly specific in your theory unless you're very, very sure on those specific pieces of evidence on which your theory turns. Because if it turns on very specific evidence, you need to be able to deliver that. And so if you approach sexual assault cases with that in mind, you will, I think, see your win rate rise. If you merely do damage to a complainant's reliability on cross-examination, you usually haven't won. What you've done is you have made room for your client to testify credibly. Because the complainant's evidence and the accused evidence are not scrutinized even by most judges. There are some judges who are even-handed about that, but you shouldn't assume that that's the case. You should assume that your client's evidence is going to tend to be greeted with suspicion by the judge. So there are cases where you can do enough damage to the complainant's credibility and or reliability that you can win it right then and there. But if you merely do some damage, you haven't yet won your case, but what you have done is you have sort of opened up your client. So if all they really have is a kind of bare denial without a whole lot of useful information backing that up, there's not a lot of meat on that bone. But if you've done enough damage to the complainant, the judge can then decide, okay, well, I'm listening to your guy. Well, there's nothing really wrong with what he's saying, and he's denying it, so I can't really be sure. But generally, if you've just got a complainant with a sensible story, not tarnished by cross-examination and an accused with a sensible story, there is no reason to think that your client is going to get acquitted, even though what the judge is being theoretically presented with are two different stories of more or less equal quality. That won't work in your client's favor nearly as often as it should. Anyone have any questions or anything they want to say? Anyone want to call me an idiot?
Unmute yourselves or type something in the chat if you prefer.
I have a
Alyssa.
question for you, Jeremy.
First, Gary, then Alyssa. Go ahead,
Okay.
Gary.
I mean, I know this is pre-trial motions that you're talking about, but do you find that you have to call your client to testify often, or as a matter of sort of ensuring that you don't mess up the trial?
My default on calling my client, like I default to off. My default answer is no. I need a reason to call my client. Like the bare denial without any sort of useful narrative, I don't find that that helps. Unless I have, like, if I've done sort of some damage, but on cross-examination, but I haven't devastated the complainant, then I like to call my complainant. If my complainant has an intelligent story, then I like to call them. And judges want to hear from the accused in these stories. I mean, judges want to hear from the accused all the time, but particularly on sexual assaults. Now, often your guy has nothing useful to say or is a problem. And most of the time, it doesn't take that long to correctly assess the usefulness of your client as a defense witness. You can't, I mean, it is their choice. But most people aren't really that excited to testify in criminal trials, including their own. So again, whenever you put your client up, you're always running the risk that they say something stupid and sink their case. And accused persons are way more vulnerable to that than complainants are to saying one stupid thing that tanks the prosecution. Like it's a much bigger risk to have your client testify. So for me, it's very context specific. I've had cases where I've called clients and they've done great. I've had cases where I've told clients, yeah, like I don't see you as being the answer. And most of those guys kind of know that. So you're not really telling them anything they don't know. There are a few delusional guys that, think the sun shines out their ass and that, whatever they say is going to get lapped up by the judge. But mostly these guys kind of know that they're, not going to present that well. And they're, just sort of happy to hear it from you. But you need a strategy. If your client can't, if your view is that your client is not going to be a viable defense asset, you need to source this theory from somewhere. Now, it can be based on cross-examination. It can just be your suggestions to the complainant that sort of intuitively make sense and, they're not sort of well able to deny. I don't know if I fully answered your question, Gary, but that's sort of my reflexive response on that.
Yeah, I remember John McCammond many years ago presenting on defending sexual assault clients, and he said that if you ever are going to call a client to testify, it's most likely in a sexual assault case, not every single time, but just in order to make sure that it's almost better that if there is a conviction that they did testify, as opposed to if there is a conviction that they didn't. But like you say, it's a judgment call, and you need to have a good reason to put them on the witness stand.
Yeah, I mean, there are guys who are just, I mean, from a client management perspective, like if you've got a guy who's going down, he's going down, all he has is a bare denial, and it sounds terrible even to you who wants, you're on his side, and you're listening to him and you're just like, ugh. Um, like for those guys, it is a better client management strategy to have called them so that when, they get convicted, you can say, look, well, you told your story, the judge didn't believe it. But I mean, if you're going to do that, like, know that's why you're doing it. It's a pretty cynical thing to do, but we live in a cynical world. So I won't say that I've never done that, but I I don't like losing. So I would rather, if I think I can do better on my own without them, I will say I think I can do better on my own because, look, I'm on your side, but I don't see you being the difference maker here. Um, but that's specific to different lawyers have different levels of comfort with like top-down directing defenses like that. I was mentored in a very top-down model, where your client has the right to decide what their plea is and whether or not they're testifying, and you make the other calls. That's how I was mentored. I've never had good reason to question that, although that does sometimes rub clients the wrong way if they really want to be, if they want the conduct of their defense to be highly democratic. I wasn't raised on that. Anyone else?
Yeah, how do you handle the bald denials? Like, I didn't do it. Well, do you have any witnesses? Do you have any evidence? Do you have anything? Nope.
I don't bother with it. If all they have is the bare denial, I just say, look, like, I you can get up there and deny it if you want, but if all you have is the bare denial and no useful information, if I can't do enough to get you acquitted on my own, the bare denial isn't going to get you acquitted. So I just tell guys that the risk reward calculus does not favor having them testify, only just to say, not me.
Yeah, those are hard ones, you know. I have one coming up right now. It's a bare denial, but apparently he was never alone with the child. And between his partner and two other family members, they always took care of the child. I guess that's, it's kind of a weird one, but I
Yeah,
guess that's
I hate that. Fun fact, I have never been alone with any of my nieces, but if I were charged with sexually assaulting one or more of them, I would not say that I have never been alone with them
why.
because it doesn't sound true.
Yeah. Yeah. No, I hear what you're saying. It's tough though. If that's all
Yeah.
you got.
Well, then you don't really have anything.
True.
So you're kind of on your own. I don't mind being on my own. Um, I just I'm comfortable being out there operating without the net. And I don't mind. I guess I've done enough of these cases that I'm not worried about, being involved in one of those where it all stands or it's all me and what I'm able to do. And I can't rely on my client to get himself out of the jam. I don't mind it. But I have a good imagination and I tend to
Right.
be good at sniffing out crazy or having things just land in my lap because of the way I ask questions. Um, Try to ask questions in as non-threatening a way as you can go. Like occasionally you have to piss off the complainant right out of the gate. But generally you want to be as innocuous and disarming as you can. And the longer you're able to keep up questioning in a non-threatening way, the more shit will just land in your lap without you knowing why it did.
Yeah. No, it's just yeah. I've done a lot of these cases too, it's
I know.
it's just it's difficult. It's kind of like guilty until proven innocent. It's getting a
They
little
really are reverse onus cases. No one wants to admit it, but they really are.
They really are. So yeah, it's tough. It is tough. I hear what you're saying though. I think that's really important. The other thing is, I have to say, I've done quite a few cases where there's new 276 or 278s. As a matter of fact, I got two coming up. But the reality is usually my sphincter twitches if I don't file one. But if I'm not filing one, I better know why I'm not filing one. Do you know what I mean?
Yeah, and I mean, like one of the things that I haven't said yet is that these are also, while I don't find them to be generally a useful gateway to an acquittal, they are a good client management strategy if you've got nothing, because you're at least able to say to the guy that you've done this thing and that thing, and that judge didn't see it our way, and
Yeah.
um, again, I've done a lot of sex assault cases. I've had one where the 276 was why I won.
Yeah. Yeah. No, it's I've had them where I won. It's been useful. In fact, I had somebody in the middle of trial whip out additional allegations on paper that they said they tried to hand to the Crown. Crazy.
Oh, that's nice. Yeah. Oh, anytime you can set a complainant against the Crown or against the police, that
Yeah.
is one of the surest roads to victory.
Yeah.
Like if you've got the Crown having to sort of take a break during the complainant's evidence and then come back with an agreed statement of facts that what they have said is just straight up not true.
Yeah.
uh, because it contradicts what the police or what they would say, what they have told you. It's great.
How do you deal with Ann Turner's recent decision, like in the Court of Appeal, where it's like common sense can be applied to victims, but not to accused?
I'm not sure I've read that. What are we talking about?
Oh, she said in a decision that you can apply common sense to your analysis of the complainant, but you can't apply. Sorry, to the accused, but you can't apply that to the complainant because everybody reacts differently.
Well, I mean, that's going. You're getting at the sort of, this is the problem with like the twin myths, right? And the idea that a real sexual assault complainant or victim wouldn't do X. And in court, you would never dare say a real sexual assault victim wouldn't find time to like have it off with her boyfriend before going to the hospital for her SAP. You wouldn't say that in court, but we all know as human beings that a real sexual assault victim is probably not gonna stop off at her boyfriend's for a quickie before doing that. Like,
Yeah.
the
Sorry, I lost the audio there.
that no, I just shut up. Yeah, the reaction of the complainant, you're not going, judges will resist acquitting on the basis of what the complainant did in the aftermath, even if what they did in the aftermath is the actual reason that the judge is acquitting. They're not going to say that's why they're acquitting. They will find some other reason to do that. And if the complainant's post-offense conduct, so to speak, is super weird and baffling, you don't need to comment on that in order for it to remain weird and baffling in the mind of the judge. That's one of those situations where, maybe your client's bare denial suddenly is worth something.
Right. All right. Sorry to bother you, but thanks for the input.
And Alyssa's been patiently waiting. Alyssa?
I just had two questions. Number one, is it ever worth putting forth a 276 application, not because you think you're going to win it, but just so that on a judge alone or, provincial court trial, the judge has that context before them?
I would say yes. I think it's naive to pretend that judges only convict for the reasons stated on the record. If you want, sometimes it's worth having a voir dire so that the judge sees the statement, even though it's not going to see the light of day. You're not calling your client to testify, but you want the judge to have seen what their story is. I think that kind of sneakiness is sometimes worthwhile.
Okay.
Especially if you don't have a ton of great tactical options.
The other question I had is, kind of in context, my 276 that I'm in the middle of right now, the woman says she had a dream my client sexually assaulted her, and then she woke up and there was blood in her underwear, so she knows it happened. But she also said in her statement that she was prostituting herself at the time. So I want to explore that issue to see if there were other explanations for the, quote unquote physical injuries.
Oh my God.
What is
That's going to be messy as shit, no pun intended.
what is have you found on actual, kind of credible 276 applications, not just context or the twin miss, what do you feel is the thing you should focus on most in those applications that you think actually should be successful?
Well, the dream, your client's jeopardy in this case is not the dream, but the blood in the underwear as corroboration, I suppose, for the suggestion that what she recalls as dreaming was just her brain interpreting the actual sexual assault that was going on. I think you have I would think that the intellectually correct argument for the 276 application is that you are looking to explore an alternate explanation for the physical distress that the complainant experienced upon awakening. And so if she's engaging in other sexual activity, that could be the explanation for that. Now, you would think she would be bleeding generally leading up to it. So I don't know how much I love that as a vehicle for success, because if she's got blood in her, unless she just came back from, like the John just dropped her off after a rough trick, and then after being a rough, and then, she falls into bed and, has this dream, you would think there would be some other evidence of discomfort. But again, even to explore that, you have to do the 276. So I think you should win the application. I don't know how good the prize at the bottom of that box of Cracker Jack is. Mm-hmm. But I think you should win the application.
What is the general, what do you think the kind of focus should be though? Where do judges tend to kind of focus their attention more in terms of the factors? What have you found is the hurdle there?
Well, again, for I haven't done a lot of 276 applications because I try to avoid them.
Avoid them. Okay.
And I haven't had a lot of reason to question my desire to avoid them. So, it's fundamentally about full answer and defense. Essentially, this this blood is being offered as circumstantial evidence that your client, physically participated in the sexual assault. And so any ability to undermine that necessitates going into sexual history that is not a part of that's not the subject matter of the offense. Now, there are a lot of versions of that cross-examination that don't really go anywhere. But I think you have to do the 276 application, and I think you should succeed.
Mhm.
I wouldn't bet real money on victory flowing from the 276 application.
Yeah. Okay, thanks, Jeremy.
My pleasure.
Anybody else have any other questions? I'm not seeing anybody.
It's because everyone's gone.
Going once, going twice. Okay, well, thanks very much, Jeremy, for everything you've now filled our brains with today. It's a lot to take in, everyone. If anybody has any follow-up questions, I'm sure Jeremy would be open to getting an email from you and do his best to try to answer those questions.
Yeah.
Otherwise, a copy of this will be posted on our Lunch and Learn page. So if anybody wants to review back to the things that Jeremy's been talking about today, that will be available, I would think, within the next week. So.
Always happy to help.
All right, having said that, thanks everyone for coming. I see some people doing some thank yous here. Like I said, Jeremy's available if you have any follow-up questions. Otherwise, everyone have a great day.
Bye.
Recording here.